Order. The sitting is resumed. We come on to the debate on deprivation of liberty safeguards assessments. Anne Coffey.
Thank you very much. I beg to move that this House has considered deprivation of liberty safeguards assessments. It is a great privilege, Mr Davis, to serve under your chairmanship. I would like to highlight today an expensive bureaucratic nightmare that is engulfing councils up and down the country. Local authorities are currently struggling to cope with a tenfold increase in applications for deprivation of liberty safeguards, known as DOLS. This is not only costing millions of pounds and tying up countless police and other resources, but is also causing untold distress to relatives of dementia sufferers who are now treated when they die as if they had died in state detention. First, we need to look at how we arrived at this unsustainable position. The deprivation of liberty safeguards, DOLS, were introduced by the Department of Health in 2009 under the Mental Capacity Act 2005. They were intended to comply with Articles 5.1 and 5.4 of the European Convention on Human Rights and to ensure that appropriate safeguards are in place to protect adults deprived of their liberty. DOLS provide a procedure for authorising any deprivation of liberty in care homes, hospitals and supported living arrangements. I am particularly interested in the increase in application for DOLS assessments from care homes. If DOLS were working effectively, the system would prevent potentially abusive restraint and sedation. It would also help to ensure that day-to-day practice in a care home does not restrict a person's liberty. For example, people with dementia should be able to move around as they wish as long as it is safe and not be required to stay in one place simply because it is easier for the staff. In March 2014, the UK Supreme Court handed down two judgments, commonly known as Cheshire West, which outlined the tests that must be used in determining whether arrangements made for the care of an individual lacking capacity amount to a deprivation of liberty. The judgment said that the key test was whether the person concerned is under continuous supervision and is not free to leave. This effectively lowered the threshold and resulted in the colossal increase in the numbers of DOLS applications to local councils. The situation was first brought to my attention by local GPs in my Stockport constituency, council officers and distressed relatives of dementia sufferers living in local care homes. To get an overview of the national picture, I tabled a parliamentary question in March, asking, with reference to the Supreme Court judgment, how many requests for a DOLS assessment there had been in each local authority area. The answer revealed massive increases. In 2012 to 13, there were just 11,887 applications for the whole year, but the latest figure for just the 3 months, January to March this year, is 36,000. Of these, 2/3, or 68%, have not been processed. The numbers are rising every month, and the Local Government Association estimates that an additional 136 million is needed this year to cope with the additional applications. From April the 1st, 2014 to the end of January 2015, Stockport received 612 applications and currently has about 230 cases which have not yet been processed. All those agreed will be automatically reassessed again in 12 months' time. Stockport Council is now spending almost 1.2 million a year on DOLS assessments, employing 6 new social workers, a special DOLS coordinator and a part-time solicitor. And the council has also had to draft in a private agency, as the average assessment takes about 9 to 12 hours each. That is a lot of time and money at a time when social care budgets are being squeezed. One of the main aspects that is worrying me on behalf of my constituents is the consequences of guidance issued by the Chief Coroner to local coroners in December 2014, subsequent to the Supreme Court judgment. It said that all deaths of people subject to a DOLS order must be investigated by the coroner whether the death was from natural causes or not, and that they are deemed to be in state detention. This means that when a dementia sufferer subject to a DOLS dies in a care home, GPs now have to notify police, who have to come and sit with the body until it is collected by the coroner's mortician and taken to the hospital mortuary, where it has to be formally identified before a formal inquest process starts. This is causing untold distress to relatives and is leading to an increased workload right across the public sector. I understand that Peter Fahy, the Chief Constable of Greater Manchester Police, has written to adult social care teams looking for information amid concern about how these changes will impact on police time and resources. One lady contacted me about her 86-year-old husband who has Alzheimer's and lives in a care home. She was very distressed about what would happen when he dies and to learn that he was classed as being in state detention. She said, "He's not a prisoner just because he has a lockable door. He is not in prison. He has done nothing wrong." The couple have been married for 60 years and she visits him every day. Another lady whose father lives in a care home told me, "I am absolutely appalled at the ruling that residents in care home with dementias and their families need to be put through so much after death. Not only will it be a drain on public services that are already stretched to the limit, but it will also prolong the agony of the grieving families at a really stressful and upsetting time." She added, "I would like the guidance to be looked at again with more compassion towards grieving families." There have been reports nationally of relatives of dementia sufferers who pass away in care homes being forced to wait months to bury loved ones because of the rules. In addition to individual constituents, I have also been approached by the local GP practice in Brinnington, Stockport, an area where there are 234 elderly care beds and 5 care homes, most of whose residents have some form of dementia. The GPs are worried that the coroner's advice would have enormous and far-reaching impact across a great deal of services, not least affecting patients and grieving relatives. Their main concern is that those subject to DOLS must have their death reported to a coroner. They pointed out that technically this could involve every single care home resident in Stockport, given that all care homes have lockable doors to help protect the welfare of residents, and therefore every resident could be liable to a DOLS assessment. Nationally, doctors are unhappy, and the British Medical Association is calling for an urgent review of DOLS to simplify the system, which they say is a time-consuming and cumbersome process and will divert resources away from frontline services. I wrote to the Chief Coroner, Judge Peter Thornton QC, to express my concerns, and he confirmed in a reply in March that, and I quote, "In my view of the law, and as set out in guidance, persons who die in a hospital or care home, subject to unauthorised DOLS, die in state detention. Their death must therefore be referred to and investigated by the coroner." He said this interpretation of the law is shared by the Ministry of Justice and the Department of Health, and it was also the view of the previous government in 2009 during the passage of the Coroners and Justice Act. However, he accepted that, and I quote, "The consequences of the law, however, may not have been appreciated at the time of enactment. They involve consideration by coroners of all DOLS cases, even where the death was from natural causes. That is unfortunate and may cause extra distress to the bereaved families, which should be avoided at all possible. Within the framework of the law at present, he goes on to say that within the framework of the law at present, I am therefore considering ways of easing the burden of such cases on families and easing the extra burden of work for coroners, an additional expense for local authorities. But this in itself may require a change in the law, which will be a matter for Parliament. I understand that the Law Commission is currently reviewing DOLS following a critical report by House of Lords Select Committee in March 2014, ironically a few days before the Supreme Court ruling, which said DOLS were not fit for purpose. However, the Law Commission's recommendations are not due until 2017, and there may be no change in practice until 2020. The setting up of the post of Chief Coroner was quite controversial. There were concerns that in trying to introduce uniformity to the system, this would take away discretion from local experienced coroners. And it would appear that this is exactly what has happened here. Local coroners who make decisions every day about whether or not to have inquests now feel obliged to have an inquest on someone because they were subject to a DOLS, even though their death was entirely expected. So inquests are not being determined by the nature of the death, but by the status of being in state detention when the person died. I have been told about a local case of a lady who died of natural causes in a care home and was cremated, only for it to be discovered afterwards that she was subject to a Dole's. The coroner then had to get permission to carry out an inquest in the absence of a body. The family were very upset because they had to revisit the death all over again. Another elderly gentleman subject to a Dole's died of a type of cancer of the lungs often linked to exposure to asbestos. There now has to be an inquest with a jury because it is an unnatural cause of death for someone subject to a Dole's. This all takes time and money. However, the Chief Coroner's guidance is essentially his opinion. Paragraph 46 states, "The Chief Coroner who sits in the High Court on coroner cases is not providing a judgment or ruling. This guidance is no more than an expression of an opinion, subject to the ruling of the High Court. Coroners, who are of course entitled to make their own independent judicial decisions, will do as they see fit in any particular case. But," and the final sentence is, "but they are invited to take this guidance into account. The Chief Coroner may argue that it is therefore up to the local coroners to make decisions. However, this last sentence has been interpreted by local coroners as an order rather than a guidance. He has, of course, the authority of a judge." It might be that if this last sentence was removed, local coroners might feel they had more discretion about when to hold an inquest. In reference to state detention, the Chief Coroner states in his guidance that there are two alternative views. The first was that the death of a person in hospital or a care home who was subject to a Dole's would not automatically require a coroner's investigation. Indeed, in most cases, there would be no deep need for an investigation, although the coroner would have to decide on a case-by-case basis whether one was necessary. However, the Chief Coroner took the second view, that a person subject to a Dole's falls squarely within the 2009 Act's definition of in-state detention. Given the distress to relatives and the diversion of resources from frontline care and his stated objective to ease the suffering of relatives, I think it is time for him to reconsider his position on state detention. Because without a shadow of a doubt, that phrase, state detention, is causing great upset to relatives who, on top of their grief, have to cope with all the additional formality of process accompanying a state detention, for example, the attendance of the police and an inquest. And I would make another point, that if all the applications had been processed for 2014 to 2015, we would have had an additional 142,902 people in state detention. This might give rise to a misunderstanding by the international community, who might think that we were approaching the levels of those detained in North Korea. So although Dole's were introduced with good intentions, we now have a situation which is out of control. The police are overloaded, GPs are overloaded, the coroners are overloaded, local authorities are spending millions of pounds from reserves, grieving relatives are in terrible distress, and 2/3 of all applications are not being processed, which means that some people are not being protected by a Dole's and may be having their liberty curtailed unnecessarily. Frankly, this is a tsunami that is fast sweeping over us. We can't wait until 2017 for the Law Commission review. We need an urgent decision. There's also concern that some of the applications are unnecessary. Residents in care homes have differing levels of capacity, and just because the care homes may have some locked doors does not mean that every resident, as a matter of course, should be referred for a Dole's. The Care Quality Commission have an important role as an inspectorate to make sure that there's proper understanding of the Mental Capacity Act and Dole's amongst care providers, as well as an understanding that they need to provide environments which can be flexible to residents' needs in ensuring the greatest amount of liberty consistent with their capacity. And I welcome the CQC inspection regime of adult care, which began in April 2014. The main concern of Care England, who represent independent care providers, is the amount of time it takes to process assessments. Because of this, many providers are being placed in the position in which their services are being inspected by the CQC, yet they do not have Dole's authorisations in place for all the residents who should have them. Care England also stressed that the delay in burials caused by waiting for inquest is also upsetting cultural norms. For example, they have care homes solely for members of the Jewish faith whose beliefs require a quick burial after death. If the coroner has to carry out a full investigation, this precludes the family from being able to carry out a quick burial. And I would like to suggest to the Minister the following way forward. The Law Commission review to be speeded up and conducted urgently before 2017. In the meantime, opportunities should be taken to change the law to make clear that not all deaths need an inquest. The Chief Coroner should be invited to look again at his guidance and review it in relation to state detention and automatic request. Perhaps the Minister might consider mounting a legal challenge to the Chief Coroner's guidance on behalf of all those who are being adversely affected by the administration of doles, including those residents in care homes who have not yet had their applications processed. Or perhaps the government should consider whether state detention should now be statutorily defined. And finally, conduct an urgent review of the doles regulations to simplify this bureaucratic and time-consuming system. For example, the fact that doles have to be reassessed automatically every 12 months. This is a sledgehammer approach by the system. It's not remotely sensitive. The issue has aroused widespread concerns. My concern on behalf of my constituents is that when their loved one dies in a care home, they should not have their grief exacerbated. Often they have spent months deliberating about admitting their relatives into a home and often feel guilty that they cannot care for them themselves. The process which now surrounds the death of a person subject to a doles adds immeasurably to their distress. When someone asks, "How did your mother die?" who wants to reply, "In state detention"? The situation must be resolved.
The question is that this House has considered deprivation of liberty safeguards assessments. Minister.
Thank you very much, Mr. Davis, and it's a pleasure to be once again under your chairmanship. Can I also thank the Honourable Lady, the member for Stockport, not only for raising an issue in which she is very closely involved and has a great deal of knowledge, but for kindly sending my office a copy of her speech to enable us to give the best possible response. I do appreciate that, and I appreciate the detailed but very measured way in which she's presented what has become a very difficult situation. She quoted the Chief Coroner saying, and I quote, "The consequences of the law, however, may not have been appreciated at the time of the enactment," quotes. I think if we all had £1 for every time that phrase was uttered, we'd all be fairly rich. But in answer to his quote, I'd say, you bet they weren't. But however, let me develop a little bit more. I welcome the opportunity to provide some clarity and some more information about what my department is doing to support professionals in relation to doles, the deprivation of liberty safeguards, which are commonly known by that acronym. Doles derives from the simple premise that a person who may lack capacity through a mental health disorder and is receiving care and support from the state has as much right to freedom and movement and choice as someone with full capacity. The background to doles is not always appreciated, but it is important, and I doubt if there's any difference between us on that. The phrase deprivation of liberty is, just like state detention, an emotive one, and it derives from the legal framework. It may seem counterintuitive, but of course there are circumstances in which a deprivation of liberty can be entirely appropriate in providing care and treatment for an individual who may lack capacity. Furthermore, it's worth emphasising that doles is firmly based within the Mental Capacity Act and as such reflects the Act's core principles, namely that a person's wishes and feelings must be central to the decision-making process and that the least restrictive form of care and treatment should be pursued wherever possible. I should also stress that doles is a positive tool in that the assessments undertaken ensure that where a person is, in the legal sense, deprived of their liberty, this must be in their best interests. I entirely agree with the Honourable Lady that where doles is working effectively, it can prevent unnecessary restrictive measures and prevent people with dementia being required to stay in one place simply because it's easier for staff. As the Honourable Lady said, until March 2014, the number of doles assessment per year was approximately 13,000. The Care Quality Commission noted in its annual reports that this figure seemed low. Then, in March 2014, in the case of Cheshire West, the Supreme Court clarified the law as to what constitutes a deprivation of liberty by setting out the so-called acid test. I won't repeat the test now, as the Honourable Lady and the House knows it full well. but it's clear that the effect of the Supreme Court judgment has been to lower the threshold for what constitutes a deprivation of liberty when compared to previous standard professional practice. And this has been borne out by official statistics from the Health and Social Care Information Centre that show, again as the Honourable Lady said, that there have been 113,000 applications in 2014-15, roughly a tenfold increase on the previous year. I will turn to the wider issues connected with that in a moment, but let me concentrate on what the Honourable Lady has spent the majority of her speech dealing with, and that is the implications for coroners. The Supreme Court's judgment had a number of unforeseen implications, and the one which has been of particular concern to her is that of the rise in coroners' investigations. The Chief Coroner for England and Wales has provided guidance to coroners in which he states his view that under the Coroners and Justice Act 2009, the death of a person who is subject to a dole's authorisation is regarded as a death in state detention, and as such should be subject to a coroner's investigation. But helpfully, the Chief Coroner does state that coroners are indeed able to make their own judgment on this matter. He also states that where appropriate, any inquest could be paper-based, and certainly that neither a jury inquest nor a post-mortem is required. Nonetheless, I have indeed heard distressing reports of coroners' investigations leading to unforeseen delays in funeral arrangements and causing great anguish for relatives. The Department has issued guidance urging local authorities to work closely with their coroner to develop a proportionate response. And I'm aware that many have actually done this, and this, for the time being, may be the way through the difficulties. I can tell you today, Mr Davis, that my department is issuing further guidance on this specific matter within the next few weeks. Furthermore, I commit to writing to the Chief Coroner to ensure we're doing all we can to encourage an approach that minimises the potential distress to relatives.
And Coffey.
If we just sort of put the question, I actually think I said in my speech, part of the problem is the fact that the Chief Coroner is a judge and his guidance is seen as, sort of a question of law. And if he could perhaps make clearer that he is giving discretion to coroners, that might also help them move forward. I wondered if the Minister might take that up with the Chief Coroner.
The Honourable Lady, in her concluding remarks, suggested that there might be a legal challenge to the coroner. I'm not persuaded at this stage that that would be the best way forward, but perhaps we might leave it that depending on the response of the Chief Coroner to my letter, I might seek a meeting with the coroner in which I might have an opportunity to talk in a slightly different manner about some of the problems which she's raised and get an opportunity to take this further. But I think I ought to get the written response of the Chief Coroner in the first place. But I appreciate the Honourable Lady's point of view. We want to encourage an approach that minimises the potential distress to relatives, which can be severe, as the Honourable Lady set out. And the key to best practice is good communication and information exchange between partners in the system. I'd like to point out Leicester City Council being indicative of a local authority that's worked closely with their local coroner. Together they've designed a shared protocol that includes the clear steer that unless there are suspicious circumstances, notification of a death can wait until office hours, negating the need for distressing out-of-hours visits from uniformed police officers. In the vast majority of these cases, police involvement will not be necessary. Certainly 999 calls are not appropriate. So I'm grateful to the Honourable Lady for stressing the importance of this. The Law Commission, that I'm going to refer to in a second, are also looking at the issue of coroners' investigations, and I want to see the results of their investigations in relation to that. Can I say a little bit more about the Law Commission side of it, having dealt with coroners to an extent? The government's policy is twofold in dealing with the significant challenge which has been given to local authorities and health and care providers now charged with implementing DOLs. Firstly, we're seeking to understand whether legislative change can provide a system that's sustainable in the long term and which better balances the protection of individuals against the need for minimum bureaucracy to ensure that existing limited resource is maximised. Secondly, we are seeking to provide practical support and guidance to manage the challenges in the interim. The case for a thorough review of the legislation in this area is unambiguous, Mr Davis. The legislation underpinning DOLs was introduced by the then government in 2007. It was criticised by select committees of both houses even before the implications of the Supreme Court judgment became clear. And now, following that judgment, the government is funding the Independent Law Commission to review the legislation underpinning dolls. It'll launch a 4-month public consultation on a proposed new scheme on the 7th of July this year. Following the Honourable Lady's intervention, it has occurred to me that she and other parliamentary colleagues may appreciate a dedicated consultation event with the Law Commission on the parliamentary estate. If the Honourable Lady agrees, I shall endeavour to make arrangements for this. I'll contact the Law Commission to suggest it, and I hope they might want to have a session here and listen to the expertise of colleagues, and I'm sure they would benefit from such expertise. And I will write to the Honourable Lady and let her know what the Law Commission make of that suggestion. I strongly believe, however, that given the criticism of the current dolls legislation and bearing in mind the likelihood of unintended consequences, it's important that the Law Commission be given the time to consider the entire legislation in the round and, if appropriate, propose a comprehensive solution. So it would be unwise to rush into specific legislative changes, the repercussions of which may not be clear, so I'm not tempted at the moment to make any changes to the regulations. But I do agree with the Honourable Lady in relation to greater urgency. The Law Commission's review was scheduled to complete in the form of detailed policy proposals and a draft bill in the summer of 2017. I think it needs to be quicker. Accordingly, in taking up my duties and seeing this issue, I've now proposed, and the Law Commission have agreed, an acceleration of the review to ensure it, in the form of detailed policy proposals and a draft bill, will be completed by the end of 2016. Now, I know that's still a length of time, but bearing in mind the complexity of this, I don't think we can afford to get the next bite at this wrong. So I hope the Honourable Lady will welcome that. But in the interim, my department has been working with various partners to support the system's response to the Supreme Court judgment. I reiterate now that the response to that judgment must be rooted in the principles and values of the Mental Capacity Act. Our efforts have to be focused primarily on realising real benefits for individuals. DOLS is about people, not paperwork. My department has issued clear guidance that has emphasised the importance of a proportionate Mental Capacity Act-centred approach, and that so-called bulk applications for all the residents of care homes are not acceptable. DOLS applies only to those who lack the specific capacity to consent to their accommodation. Many in care homes and hospitals will have this capacity and so not be eligible for DOLS. That must be made clear. We also recognise that the scale of the challenge set by the Supreme Court means that some local authorities will be unable to process DOLS applications within the 21-day legal timeframe. The Care Quality Commission has been clear that providers will not be unfairly punished for such technical breaches. But the CQC has also been equally clear, quite rightly, that a do-nothing approach is unacceptable. So providers and local authorities must have a plan in place for ensuring that those who stand most to benefit from a DOLS assessment receive one in a timely manner. The department has funded a reduction in the non-statutory bureaucracy accompanying the DOLS process, reducing the number of application forms from 32 to 13. The Association of Directors of Adult Social Services who delivered this project deserve particular praise for the support they've provided to their member organisations since the Supreme Court judgment. The department has also funded the Law Society to produce excellent comprehensive guidance in collaboration with practitioners to assist in identifying a true deprivation of liberty. And in March this year, the government announced it would provide local authorities with an extra £25 million to support their efforts on DOLS in 2015-2016. I've reassured the Honourable Lady that I do understand the concerns some local authorities have as a result of the cost of DOLS, and I praise the hard work of local DOLS teams. But I'm also aware there's considerable variation among local authorities in terms of the number of applications they've been able to process. Clearly, it's important we identify and learn from current best practices. So my officials are in close contact with providers and local authorities, and I've instructed them to make further visits across England this summer to continue to understand the local response. While some may balk at 100,000 DOLS applications a year, we should remember that every one of these applications does represent a person having their care independently scrutinised. DOLS can help shine a light on care that's unnecessarily restrictive and which does not put that person's views first and foremost. And therefore I think we should strongly back the principles of DOLS. But our shared challenge now, through the Law Commission review, is to understand how these principles can be better applied in the day-to-day reality of the health and care system and after the unintended consequences that we've seen as a result of that judgment. So I thank the Honourable Lady for raising these important issues today. My department would be grateful for any further insight that she may have, conscious as we are of her expertise in the social care field. So I hope we've touched this afternoon.
Order.